The legal battle between the federal government of Nigeria and the Irish gas exploration outfit, Process and Industrial Development Limited, P&ID, is getting attention again following weeks and weeks of an onslaught unleashed on the economy by the coronavirus pandemic. The government yesterday reaffirmed to a British court that the contract in question was all a carefully orchestrated fraudulent scheme involving certain top government officials from Nigeria and, of course, P&ID itself. It's worth recalling that another British court had, before the appeal, awarded a $9.6 billion cost against Nigeria for failing to live up to the terms of that contract. Joining us now to recap on what has thus far happened with this case and the likely options and possibilities before Nigeria in the event of the two possible outcomes in the case is Professor Konyin Ajayi, Senior Advocate of Nigeria, and Managing Partner Olaniwun Ajayi Legal Practitioners. Professor Ajayi, good morning and welcome to the morning show. Thank you for joining us.
Good morning, sir.
Morning, sir.
Good morning.
Morning. Mr. Abati, good morning.
Good morning. Thank you for joining us. We really appreciate this very much. Well, I mean, we've been battling with COVID-19, but the issue of P&ID has been in court. For the benefit of our viewers who may not really understand the facts of the case, I don't know whether you can assist us to just put a fence around it again, just for our viewers to know what exactly is at stake.
I think this goes back to quest to do two things. One, or I'll say three things. The first is to improve power supply in the country, which was the ostensible reason for the entry into the contract in January 2010 with this company. The second was, again, to harness our natural resource. So it was a contract to process wet gas and from it take lean gas, which will be supplied to power generating companies to supply power to the country, and the natural gas liquids that would come out of the process to be taken by P&ID as part of its compensation for the contract. It was a 20-year concession to be based in the South. And this, as I said, was a contract that was negotiated and entered into in 2010, January 2010. As we now read, it was a contract entered into by the Ministry of Petroleum Affairs and this company. Now, what we know from court papers that have been filed in England, from what we also read about the prosecution that EFCC has undertaken and concluded in Nigeria with respect to the case, is as follows, which takes us to the third leg of what brought about this case. And the third leg is a cesspool of corruption and mediocrity that we suffer as a country. And why do I say this? So you have P&ID, a company registered in Nigeria with two Nigerian shareholders, one who happens to be a lawyer, and the second, another Nigerian whose name I do not remember. These clearly were nominees of the principal parties behind P&D, two Irish men, one who is said to have died in 2015. These two Irishmen formed P&ID in Nigeria through these Nigerians, and also had another company incorporated in the British Virgin Islands. What we know and what we read is that these two Irishmen had been in Nigeria for a while, and they were wheeler dealers, dealing in all kinds of contracts, small contracts, big contracts, acting as commissioned agents and did some military hardware and so on and so forth. What you also read now from public papers is that they had an arrangement with one of very large companies owned by General Danjuma and his wife. And it is alleged, according to the papers by General Danjuma, that he hired Mr. Quinn, one of the promoters of P&ID, to undertake feasibility and look at the possibility of, dealing in, this project. And he's said to have spent 40 million United States dollars. So fast forward to this contract. So we enter into this contract, Nigeria, through the Ministry of Petroleum Resources, with this company. Now, mark you, according to papers that are in the public domain, this is a company that is not well capitalized, newly formed company, enters into this contract with the Ministry of Petroleum. Now, as we all know, our ministries are not asset-owning instrumentalities of government. Our gas is owned by the federal government through the NNPC and not through the ministry. So nowhere would you find Ministry of Petroleum owning any of our natural resources. They don't own crude oil, they don't own natural gas. So the first question you ask yourself is, why would the Ministry of Petroleum enter into a contract to supply natural gas when it has no natural gas to supply? So that's the very first question that you must ask yourself, and it begins to point to one of two things: either terrible mediocrity, and I would not say, Alhaji Lukman Rilwan is in any way mediocre. Very brilliant petroleum engineer, Minister for Petroleum, was Secretary General of OPEC, so clearly not a mediocre. And you had the legal advisor of the ministry, at that time, Mrs. Tiger, who also you cannot say is mediocre, being legal advisor of such a ministry. So it could only have been something else, which is what government now alleges. But I don't know, but it's still an allegation. So if we're going to be very fair, we'll just say it was pure mediocrity on their part, and clearly on the part of the chaps entering into this contract, something other than legitimate. Because if they say that they are businessmen in the business of processing natural gas, they must know that the Ministry of Petroleum cannot enter into a contract with them to supply them natural gas, number one. Ministry of Petroleum cannot enter into a contract with them to produce power. And Ministry of Petroleum also is not the one that would generally award a contract to build gas pipelines. Anyway, so we enter into this contract, a 20-year contract, for them to build this gas processing facility, much as you have Nigeria LNG, a company with NNPC, Shell, Total, and Ajib as shareholders, and they built this facility. We all can see it. At the time, it was the largest industrial establishment in the continent. I believe Dangote's petrochemical complex will probably be larger than this when it finishes. But be that as it may, it begins to tell you that there was something fishy, there was something wrong at the time they entered into this contract. But we entered into it, and 2 years after, P&ID alleges that government has breached contract. And what was the breach? They said government had not supplied the gas. So they went to arbitration. Appointed a highly respected former English judge, Sir Anthony Evans, as arbitrator, and Nigeria appointed a highly respected senior advocate of Nigeria, former president of the Nigerian Bar, former Attorney General, Chief Bayojo, SAN, as their own arbitrator, and both of them appointed another highly respected English judge, former judge, Lord Justice Hoffman, as third arbitrator, who was chairman of the panel. And so, I don't want to get technical, they went into the arbitration, they started the arbitration, you know, at the end of 2012, early 2013. And so, you know, the back and forth, the case was fought, and they got to a stage where Nigeria said, well, hang on, this tribunal has no jurisdiction to deal with this proceedings. Nigeria lost the argument. The arbitration panel ruled that they had jurisdiction to deal with this. And so, you know, what did this mean? So Nigeria said, look, this is a matter that this tribunal as constituted cannot handle for a number of reasons. Some of which was that the contract was bad and so on and so forth. But not getting technical, we said they couldn't do it, they didn't have the power to do it, and so on and so forth. Now, what did the contract say? Now, the contract provided, or provides, that when there's a dispute, it will go to arbitration according to Nigerian Arbitration Act, and that it should be in English language. However, it says that the venue, and use the word carefully, the venue of the arbitration will be London. In other words, that they would go to London, the arbitrators, the lawyers, and the parties would go to London and, undertake this arbitration. Now, in arbitration, there are three terms that are very relevant here, and I'm going to come back to what happened. We have something we call the venue, which, as we all know, is a place where we sit. It's a physical place. In arbitration, you also have a place called the place of arbitration, which is also, as you would imagine, something that is physical. And then we have a third term, which is called the seat, as in a seat. But that seat is not a physical thing. The seat is a legal term which is used to describe the laws that will be relevant to the supervision of the arbitration proceedings. Now, let us not forget that arbitration is an alternative to going to court, right? So the parties have agreed that rather than go to court, we will go to, neutral parties to decide the case for us and accept what they do as if they are sitting as judges, or maybe the judge of the Federal High Court, or judge of the Lagos State High Court, or Abuja High Court, or whatever, or, and so on and so forth. So it was agreed arbitration would be, the physical place would be in London, but that the arbitration will be supervised according to Nigerian law by Nigerian courts. That's what a seat determines. But the contract did not mention a seat. And a big question then arose as to where is the seat of the arbitration. And it became a very big issue in this matter. So after Nigeria went to the arbitrators and said, you have no jurisdiction, the tribunal said, we have jurisdiction, we're sitting in England, and we will continue with the case. So they continued with the case. Nigeria did nothing at that time. And first question is, should Nigeria have then applied to set aside the decision of the tribunal, which we call an award, that it had jurisdiction?
Can I come in here,
With the benefit of hindsight, it ought to have done so.
Yeah,
but
so this is...
Yes, please do.
Can I come in here at this point, sir? So this is what a lot of people are asking.
Yes.
The apparent indolence on the part of Nigeria. Because thank you for taking us through this in great detail. a lot of what you say, you started off using the word ostensibly. I want to ask you about that because P&ID claim that this contract would have given Nigeria 2,000 megawatts added to our national grid, but the facts show that they never had the capacity to deliver that. So that use of the word ostensibly, can we please expand on that? And that the fact that the federal government is claiming fraud, how much of a defense is that at this stage? And you also talked about mediocrity or some other factor, which reminded me of Hanlon's razor, never attribute to malice, that which can be explained by stupidity. So in this case, mediocrity. If it's not mediocrity, is it truly fraud, and how much of a defense is that?
All right, okay. So I'll just finish very quickly on seat because it turned, the arbitration, the case as we have turned on that. So what happened is that the arbitral tribunal said Nigeria was wrong. And then Nigeria came to Nigeria, federal government came to Nigeria and sued at the Federal High Court and said the Federal High Court should set aside the award that Nigeria was wrong. Justice Buba issued an order that the arbitration tribunal should stop working and set aside the award that Nigeria was wrong, right? They went back to England, and England arbitration said, we don't mind Justice Buba of Federal High Court. We are the seat. London is the seat, not Nigeria, and therefore we will continue with what we're doing. And then they then awarded damages. Now, P&ID initially sued for $5.9 billion and then increased it to $6.5 billion. An award was given for $6.6 billion, not 9.6, 6.6 plus interest at 7% from 2013 up until whenever it is paid. So by the time Justice Butcher then said, yes, go and enforce the award, the amount became $9.6 billion. Today, the money is more than $9.6 billion, actually. It will be over $10 billion. So coming to your question, could we say there is a fraud? Was there anything that was properly done? Now, this is the fact, and this is what we begin to look at in the award. So you have P&ID, this company that did not have any licenses. This company that did not import one steel, that did not have one bag of cement, that did not have any land on which it would build this power plant. I mentioned Nigeria LNG deliberately because that is the kind of facility that they were going to build. So they built nothing. They did nothing. Right, okay. Nigerian government was supposed to have built a pipeline to their site and to have supplied gas to their site. We did not build it. Yes, it is true. We breached contract. We did not build a pipeline. We breached contract. The contract said we would assist them to get licenses. We did not assist them. But did they show that they applied for the licenses? Did they do anything? So they did nothing. So it cannot but be a grand fraud on the people of this country. How can someone who did not buy land, who did not turn the sword, who did not break ground, who did not show he had brought in engineers, who did not show that he had the technology, now claim that he lost money? So this is where the fraud on Nigeria lies. It's an example of the kinds of things that are done to rape us. These are the kind of things that demonstrate the knee on the neck of the people of this country, suffocating us in respect of our natural resources. So it is nothing but a grand fraud. And why is this so? And I'll just say this. So EFCC has done something. EFCC has investigated and has found payments from P&ID to public officials in Nigeria. And we know that one of them, Mrs. Tiger, is standing trial as we speak. We know that two agents, the two shareholders of P&ID Nigeria, have been charged to court, pleaded guilty to tax evasion and money laundering, and been convicted. And what was the money laundering? They found that this company in Nigeria was laundering money and wasn't doing anything else. So it cannot but be a fraud on us. It cannot be evidence of corruption. Okay. And it is a defense for us, and maybe we'll get into that as we progress
I just wanted to ask
program.
this.
Yes.
I think it was Martin Luther that constantly talked about not the silence of our friends will hurt the most, not even the fact that people didn't speak up, but the silence of those very close to us. And in this, I'll juxtapose it with the other Nigerians that were part of this, what you call a fraud. And I would like to know, is this not a case of Nigerians robbing Nigeria? And is this not a case of the contract scam? If you read the book by Ngozi Okonjo-Iweala, Reforming the Irreformable, she talked about in different types of scams. She talked about something called the contract scam, where you have a contract with the federal government. People in those ministries and MDAs will come to you and say, okay, this is how we'll do it. They will deliberately make the government default on that contract. They will take you to court. They will ensure they do everything to make you win the case. They'll pay the interest on the contract fee, and you'll get your money, and they'll all share it in the end. Is this not another clear case of the contract scam and the Nigerians involved? Because P&ID couldn't have done this if they didn't have Nigerian partners. I want you to talk about that.
Oh, clearly, I mean, this is more than fraud. It's more than larceny. It is armed robbery with a pen. And, you know, we must view it as such because it's a rape on us. And without any doubt, Mr. Quinn and his partner had very, very active Nigerian participants in this grand scheme. So it wasn't just two foreigners coming here, parachuting into the country and stealing our assets. They had a whole set of people that were part of this scam. Yes, this was a big scam, and we have to call a spade a spade. God bless Alhaji Lukman Wilwan, but he's not here to defend himself, but he's named in the papers. I cannot believe that he will sign such a contract, that he will sign a contract by his ministry when he knew his ministry had no gas to give, when he knew his ministry had no money to build a pipeline. The question is, it wasn't appropriated for in that year. So they knew what they were doing. They knew this was wrong. And then we've been told, what we've seen from evidence presented by EFC, monies paid into the accounts of a number of civil servants. So yes, we were silent in the face of evil. But then let's go beyond the active participants in this scheme. Let us go to what then happened. So Nigerian government, after judgment was given against us, had the opportunity to do something, but we did nothing. According to the judge before whom we appeared, Nigeria came over 4 months after it ought to have come. And one of the reasons why we lost was what the court described as a lethargy and a mediocrity and the fact that we just were not doing things properly. So one ministry official, they posted an affidavit after this government came in that there was change of government. But we cannot say that. Government is a continuum. Government is a continuum. Government doesn't stop. Yes, there was change of government. Yes, there was a new Attorney General, but there was no new permanent secretary. There was no new director of foreign affairs. There was no new, and so on and so on and so on and so forth. So, it is unfortunate that our public servants do not rise to the occasion. So we allowed the fact that there was a change of government to let this slip. And we did not appeal on time. And that is where we got into this trouble. Luckily, we've been able to open the door once again, both in the US and in the UK.
Well, how much of a chance do we have this time, considering the fact that we've been dropping the ball consistently on this matter and we've been losing? We lost at the arbitration tribunal. We lost at the commercial court of Justice Butcher. When we tried to stop the enforcement of the award against Nigeria. We also lost at the English Court of Appeal. In fact, our case was dismissed as being misconceived. But do we stand any chance now? Do you have any hope that Nigeria will be able to get the reprieve that it is seeking?
Yeah, yes, I think we have great, not just hope. Yes, we have hope, but I think we have a very reasonable chance of success. First of all, in the United States, the Court of Appeal gave us judgment. So the P&ID went to court in America to seek to enforce the judgment. Nigeria objected to the proceedings on the grounds of immunity. The district court said, well, I'm not going to hear your immunity. I'm going to hear your immunity and the proceedings to enforce at the same time. We appealed to the Court of Appeal, and the Court of Appeal said the district court was wrong. It must hear our defense on immunity. And our defense on immunity under U.S. law is very strong. Ironclad in respect of CBN, which is generally, the government instrumentality that most people go against abroad, they would, and other agents of government, and we have reasonable good degree of success in terms of claiming immunity in that regard. So we have that. We've won half the battle there. So we're still deep in battle in the United States. In the UK, Justice Butcher granted an order to enforce the award. We lost an application to extend time to appeal to set aside the award. We have appealed that now. We have been granted leave. We've been granted leave to challenge the decision to enforce the award. We've been granted an order in America to look at bank accounts of people that Nigeria alleges were part of the fraud. So we're ticking the box. We're gradually, slowly moving forward. Now, there is something called the Mauritius Convention, which is a convention made with respect to arbitration relating to investments by foreigners in states, so investor-state arbitration. And it talks of transparency, and it talks of encouraging arbitrators to try and ensure that they are not willing tools in enforcing contract scams, that they must go beyond the veil and see to assurance that there is justice in the matter, which is what we're talking about in this case. Too technical an approach was taken at the arbitral tribunal in this matter. If they only just breasted out a bit more when they were about to get to the tape, they would have found that this was a fraud. They would have found that, yes, the federal government did not issue licenses, did not build a pipeline, but then these guys were not serious because they had not acquired land and they had done nothing. So even if there was a question of damages, it would not be as if these guys had actually spent $2 billion or $5 billion in building a plant and therefore would have been entitled to legitimate damages. So the damages that were awarded was no way a compensation. It was a penalty, which the law does not afford them. So do we have a chance of success? I would say a reasonable degree of success, more so that A, we've been able to convict the company in Nigeria, and other people have been tried for corruption in Nigeria. I hope that the UK courts would not be engines of fraud with respect to a country they say they respect, a country they say they want to do business with.
We certainly hope so too, sir. I did wonder why it was the damages awarded, which was initially $6.6 billion, merely for repudiation. It wasn't like any outlay had been, any investment had been made, as you said. That was somewhat harsh. Now, we have been granted a state of execution, and Nigeria has provided a $200 million bond. Can we talk about that? Because at the time, the Attorney General made a statement that that's a positive step. To a lot of Nigerians, it did not seem so positive.
Well, it is a positive step because the alternative would have been seizure of 30% of our external reserves. Our external reserves are about $33 billion. $33 billion. If they seize 10 billion, I mean, we will be in trouble in the country, without any doubt. Our exchange rate will go out of the roof. Our balance of trade will be terribly affected, and it just affects everything we do as a country. So it is a success that we're able to obtain a stay of enforcement. It is a major success because, remember, there is a judgment or an award. Where there is an award, no matter how bad, there is a judgment, no matter how bad, that stands against Nigeria today. So we ought not to have allowed it to get there, but we got there. And our prayer as a people is that we ultimately prevail.
I like to posit scenarios. What if this doesn't go our way? Can we still take another step? What can we do?
Well, so, if it doesn't go our way, the fact is that P&ID Nigeria has been convicted in Nigeria, and the court gave an order winding it up, gave a winding up order against the company because it's a shell involved in money laundering and tax evasion, and gave an order appointing the official liquidator as the liquidator. So all the assets of the company are being taken by the government of Nigeria. So it's okay. They get their judgment. They enforce it. But the company has been liquidated. So I would expect us to go after those assets in the hands of this company as trustees for the Nigerian people, because an order which is still subsisting, which is enforceable in England, this order liquidating the company will be recognized hopefully in England, will therefore make sure that whatever, it will just be what they get from their left hand, we will take with our right hand, and it will come back to us.
But how possible is that if the company is domiciled in British Virgin Islands?
Right. So this is it. So the contract party is a Nigerian company, and then the interesting thing, and one of the things that came out in the EFCC prosecution of the company, is that to show you the fraud, you had two Nigerians that up till the time of prosecution are in the books of the company in CAC, the shareholders and directors of the company. But the contracts and payments and bank accounts were being signed by Queen and somebody else. It just shows you that the whole thing is a fraud. Now, the English courts have said that an English statute has provided that England would not be a haven for corruption. So they have their Corrupt Practices Act, they have their Proceeds of Corrupt Practices Act, they have legislation that seeks to ensure that dirty money doesn't stay in their society. So I'm expecting that at the right time, Nigeria would seek to take advantage of the different pieces of legislation in England that seeks to ensure that corrupt monies do not stay there. I will look at Nigeria, relying on English decisions that have said that the English courts would do their best to ensure that the British courts are not engines of fraud, and that what England stands for is that it would like to continue to be the place to go for international dispute resolution. If it has a reputation of being a center for assistance of aiding crime, it will be seen no better than other havens that are blacklisted for being havens for money laundering. And I'm sure that England would not let $10 billion damage its reputation as an international center for finance and dispute settlement.
Well, in other words, can we say that if we lose at this point, then of course we have the possibility of further appeal? But the question I was really going to ask you is about the omissions that we have identified, the mediocrity that you talked about, and even more importantly, the revelation that there are similar cases that Nigeria has in other jurisdictions. What can we do to make sure that the public sector in Nigeria does not become a playfield for people who want to defraud the country, or persons who are given responsibilities but are no better than sheer mediocres?
Yes, so a number of things. We have to invest in our institutions, and I hope that this administration, which says it is has as one of its pillars a war against corruption, should realize that as long as it continues to chase to treat leprosy or to treat eczema when the problem is a cancer, we will not get out of this rot. It seems to me that we spend so much time turning our war on corruption into a circus. As you can see from the Magu fight now, which is up in the air. You've also shown us the Joy Nunye Akpabio fight, which is up in the air, how there are just no institutions and processes in government. And the government seems to be focusing on the wrong things. They do try by media. And one of the allegations against Magu by the Attorney General is that he's turned the fight against corruption as into a circus. The other thing that seems to be evident is that corruption war seems to have been a war against enemies of state. I mean, Akpabio was alleged to have stolen 10 billion naira by the CFCC. He dumped his party, changed party, and the charges went away. So as long as I know that I am in the right party, nothing will happen to me. I'll continue to do these things. So it is fundamentally important that this government begins to invest more on institution building and the proper observance of the rule of law, as opposed to a fight of corruption, which seems to be a war against enemies of state.
Thank you very much, Prof. On that note, we can only say thank you very much indeed for this very exciting conversation this morning.